Mr. President, I'd like to share my remarks not only with my colleagues today, but more so with those who will come after us. And I want to touch on 4 issues: the trial itself, the President's actions as outlined in Articles 1 and 2 of the Articles of Impeachment, and finally, and most importantly in my mind, the implications of our decision this week on the future of our government and our country. First, the trial. Weeks ago, I joined my colleagues in swearing an oath to do impartial justice. And since that time, I've done everything possible to fulfill that responsibility. I've paid full attention, taken 3 legal pads worth of notes, reviewed press accounts, and had conversations with my colleagues and citizens in my home state of Maine. The one question I got most frequently back home was how we could proceed without calling relevant witnesses and securing the documents that would confirm or deny the charges against the President, which are at the heart of this matter. But for the first time in American history, we failed to do so. We robbed ourselves and the American people of a full record of this President's misuse of his office. This failure stains this institution, undermines tomorrow's verdict, and creates a precedent that will haunt those who come after us, and indeed will haunt the country. But now we're here, left to make this decision without the facts concealed by the White House and left concealed by the votes of this body last Friday. This was not a trial in any real sense. It was instead an argument based upon a partial but still damning record. How much better it could have been had we had access to all the facts, facts which will eventually come out, but too late to inform our decisions. As to the articles of themselves, I should begin by saying I have always been a conservative on the subject of impeachment. For the better part of the last 3 years, I have argued both publicly and privately against the idea. Impeachment should not be a tool to remove a president on the basis of policy disagreements. The president's lawyers are right when they argue that this would change our system of government and dangerously weaken any president. But this reluctance must give way if it requires my turning a blind eye to what happened last summer. The events of last summer were no policy disagreement. They were a deliberate series of acts whereby the president sought to use the power of his office in his own personal and political interest, specifically by pressuring a government of a strategic partner, a partner, by the way, significantly dependent upon our moral and financial support, pressuring that government to take action against one of the president's political rivals and thereby undermine the integrity of the coming American election. And this last point is important. In normal circumstances, the argument of the president's defenders that impeachment is not necessary because the election is less than a year away would be persuasive. I can understand that. But the president in this matter was attempting to undermine that very election. And he gives every indication that he will continue to do so. He has expressed no understanding that he did anything wrong, let alone anything resembling remorse. Impeachment is not a punishment, it's a prevention. And the only way, unfortunately, to keep an unrepentant president from repeating his wrongful actions is removal. And this president has made it plain that he will listen to nothing else. Article 1 charges a clear abuse of power in inviting foreign interference with the upcoming election. Inviting foreign interference with the upcoming election. The president tasked his personal attorney to work with a foreign head of state to induce an investigation or just the mere announcement of an investigation that could harm one of the president's top political rivals. And to compel the Ukrainians to do so, he unilaterally withheld nearly $400 million appropriated by Congress to help them fend off Russia's naked and relentless aggression. The president's backers claim that this was done in an effort to root out corruption. So why not use official channels? Why did he focus on no examples of corruption generally, other than ones directly affecting his political fortunes? And why did he not make public the withholding of funds, as the executive branch typically does, when seeking to leverage federal monies for policy goals? No matter how many times the president claims his phone call with President Zelensky was not perfect, it simply wasn't. He clearly solicited foreign interference in our elections. He disregarded a congressionally passed law. He imperiled the security of a key American partner. He undermined our own national security. And if he was simply pursuing our national interests rather than his own, why was his personal attorney, Rudy Giuliani, put in charge? Why was Rudy Giuliani mentioned in that phone call? Put bluntly, no matter the defense, and as a majority of the members of this body apparently now recognize, President Trump placed his own political interests above the national interests he has sworn to protect. And as I mentioned, he has shown no sign that he'll stop doing so when the next occasion arises, as it surely will. The implications of acquitting the president on Article 1 are serious. This president will likely do it again, and future presidents will be unbound from any restraints on the use of the world's most powerful political office for their own personal political gain. We are moving dangerously close to an elected monarch, the very thing the framers feared most. Article 2, to me, is even more serious in its long-term implications. Article 1 concerns an incident, an egregious misuse of power to be sure, but a specific set of actions in time. A scheme is probably the most appropriate description, which took place over the course of the past year. Article 2, however, which concerns the president's wholesale obstruction of the impeachment process itself, goes to the heart of Congress's constitutionally derived power to investigate wrongdoing by this or any future president. I do not arrive at this conclusion lightly. I take seriously the White House counsel's argument that there is a legitimate separation of power issue here, that executive privilege is real, although I have to note it was never actually asserted in this case, but that executive privilege is real and that there must be limits on Congress's ability to intrude upon the executive function. But in this case, despite counsel's questions about which authorizing resolution passed when or whether the House should have more vigorously pursued judicial remedies, the record is clear and is summarized in the White House letter to the House in early October that the president and his administration, quote, cannot participate in the impeachment process, cannot participate. To me, it is this ongoing blanket refusal to cooperate in any way, no witnesses, no documents, no evidence of any kind, that undermines the assertion that a categorical refusal, with overt witness intimidation thrown in, was based upon any legitimate, narrowly tailored legal or constitutional privilege. No prior president has ever taken such a position. And the argument that this blanket obstruction should be tested in court is severely undercut by the administration's recent argument that the courts have no jurisdiction over such disputes, and that the remedy for stonewalling Congress is, you guessed it, impeachment. They argued that in the federal court in Washington this week. Interestingly, the first assertion of executive privilege was by George Washington when the House sought background documents on the Jay Treaty. Washington rested his refusal to produce those documents on the idea that the House had no jurisdiction over matters of foreign policy. But interestingly, Washington, in his message to Congress, did specify one instance where the House would have a legitimate claim on the document's release. What was the instance? You guessed it, impeachment. If allowed to stand, this position that the president, any president, can use his or her position to totally obstruct the production of evidence of their own wrongdoing eviscerates the impeachment power entirely. And it compromises the ongoing authority of Congress to provide any meaningful oversight of the executive whatsoever. For these and other reasons, Mr. President, I will vote guilty on both articles of impeachment. A final point. Madam President, the Congress has been committing slow motion institutional suicide for the past 70 years, abdicating its constitutional authorities and responsibilities one by one. The war power effectively in the hands of the president since 1942. Authority over trade with other countries, superseded by unilateral, presidentially imposed tariffs on friends and foes alike. And even the power of the purse, which a supine Congress ceded to the president last year, enabling him to rewrite our duly passed appropriations bill to substitute his priorities for ours. And now, this. The structure of our Constitution is based upon the bedrock principle that the concentration of power is dangerous, that power divided and shared is the best long-term assurance of liberty. To the extent we compromise that principle, give up powers the framers bestowed upon us, and acquiesce to the growth of an imperial presidency, we are failing. We are failing our oaths. We are failing our most fundamental responsibility. We are failing the American people. History may record this week as a turning point in the American experiment, the day that we stepped away from the framers' vision, enabled a new and unbounded presidency, and made ourselves observers rather than full participants in the shaping of our country's future. Madam President, I sincerely hope I am wrong in all of this, but I deeply fear that I am right. Thank you, Madam President. I yield the floor.
Madam President.
Majority Leader.
I ask unanimous consent that notwithstanding the resolution of